Why should you care about mandatory arbitration? Stay tuned.
Welcome to the YouTube channel of Michael J. Swanson. Michael is the author of How David Beats Goliath and is the CEO of Advocate Capital. And now, here's Michael.
You may have heard a lot about mandatory arbitration lately in the news, so to help us learn about that important topic, I've asked an expert in the field, Larry Bodine, to join us today. Hi, Larry.
Hello, Mike. How are you doing?
Doing great, thank you. I know that as editor-in-chief of personalinjury.com, you've done a lot of research on mandatory arbitration. So could you first tell our viewers, what is mandatory arbitration?
Mandatory arbitration is something that you find in many consumer contracts, everything ranging from cell phone contracts to car loans, nursing home contracts, even your checking account with your bank. And it's usually hidden far back in the boilerplate. And essentially what it does is it says if you have a dispute with a company, you must take it to arbitration and you give up your legal rights to take it to court.
Wow, so people are waiving their Seventh Amendment right to a jury trial without realizing it.
Well, that's right, and we fought the Revolutionary War over the right to trial, and I think our founding fathers would be rolling in their graves if they knew how commonplace these arbitration clauses are in consumer contracts.
Well, tell us, why do companies put these, if they're bad, why do companies put these clauses in their contracts?
Well, it's an effort by the big banks and the corporations to basically suppress legitimate claims and to make sure that if there is a dispute, the consumer loses. So for instance, the U.S. Consumer Financial Protection Bureau did a research study of 1,060 arbitration cases, and they found that consumers won in these cases only 7% of the time. So all the other cases were won by the corporations, so you can see why they prefer them.
Wow, so the deck is really stacked against consumers. So who picks the arbitration company?
The arbitrator is typically chosen by the corporation so that the arbitrator, of course, has an incentive to rule in favor of the corporation so that they get more business. But it puts a consumer, Mike, into a black box. These hearings are not open to the public. They're private. There is no public complaint. And these decisions by the arbitrators are almost impossible to appeal.
Do you think most people know about mandatory arbitration?
Good question. The government did a survey and asked consumers if they even knew what an arbitration clause was or that it existed in their contracts. 75 consumers said that they hadn't ever heard of such a thing. They're completely unaware of this.
Wow.
Just to show you how well hidden these contracts are, I took a look at my own cell phone contract, and it was 22 pages of fine print.
Wow.
And on page 7, there was a clause that basically said if I had a dispute, it had to go to arbitration, I waived my right to a jury trial, and I waived my right to join a class action, which is one of the major motives for creating these clauses.
So one more way that corporations are evading responsibility when they do something wrong. Crazy. Well, I'm going to put a link to the article that you wrote about this below this video on YouTube. But you also have a suggestion, something people can actually do to try to make a difference. And what's that?
Well, there are a lot of things you can do. Number one is sign the petition to have the Consumer Finance Protection Bureau ban arbitration clauses in consumer contracts. If you go to personalinjury.com in my article, there's a link to the petition. Other things consumers can do is self-protection. Read the fine print, ask the vendor if there's an arbitration clause, and if you find one, tell them you're not going to sign it. Find yourself a different bank, a different cell phone company, a different credit card company. Not all of them include these clauses.
Ah, okay. Yeah, I actually learned from reading your article, and I leased a car recently, and lo and behold, in the fine print, there was a mandatory arbitration clause, and I told them I'm not signing that. I crossed it out, and they let me do it.
Oh, well, that's a positive development, because these arbitration clauses only became popular after a U.S. Supreme Court opinion in 2011, which upheld the legality of an arbitration clause. In other words, you could contract away your constitutional rights. And after that, corporations started including them in everything. So buyer beware.
Yeah, absolutely. Well, I signed that petition myself, and I'll put a link to that petition also below this video on YouTube. Larry, thank you so much for helping us learn about the dangers of mandatory arbitration and what we can do about it. Thanks for joining us.
My pleasure, Mike.
Take care.
Thanks for watching. Send your questions or comments to Michael at mike@howdavidbeatsgoliath.com.